Daniel Herbert is Jason Van Dyke's attorney. Mr. Herbert, you've insisted that your client's shooting was justified, yet on the video, it does not appear as though Laquan McDonald was moving toward the officers, including your client. How do you explain that?
Well, I came to the same conclusion that most people are coming to after viewing it the first time, and only after I did some more investigation, namely speaking to my client and also speaking with nationally recognized experts in the area of use of force, did I come to the conclusion that his actions were justified. There's some important points to point out, which obviously will become part of the court case, but it's not uncommon for individuals to be shot in the back, and it's not uncommon for people to be shot after they've gone to the ground, and that's simply science at play. When a police officer sees a threat, it takes him a while to process that threat, and that time frame between when he sees it and when he takes action, there is a lag time. It's been explained to me similar to like an umpire in baseball, that as soon as that ball crosses the plate, the umpire has made the decision whether it's a ball or strike. However, it's not until well after the ball goes into the catcher's mitt that the umpire makes the signal. And it's similar to that, although it's even more pronounced in a case in which it's life and death and there's physiological changes to the body.
So is that how you will argue, how you will explain why your client shot his weapon 16 times in 15 seconds? It was a lot of firing in a very short period of time.
Yeah, that is part of how we'll explain it. And, you know, part of the explanation is, and it's unfamiliar to people that are not trained in use of force, but a police officer with average skills handling a weapon can fire 4 to 5 shots in 1 second. So it's very likely that that the first volley of shots, either 12 or 13 shots, was fired in 3 seconds. So I know it appears excessive to people that are uneducated in the field of use of force, civilians namely, but there's been so many studies on this, and that's exactly what our expert will explain to the judge or jury.
Mr. Herbert, you're talking about how civilians might perceive this. The fact of the matter is the Cook County State's Attorney said there were 7 other officers on the scene, in addition to your client, who did not feel that that use of force was necessary. He was the only one who shot the suspect here, or the young man here. How do you explain that discrepancy in how threatened the officers felt compared to with, you know, your client and how he felt threatened?
Well, nobody was in the position that my client was in. My client was in a position where he was clearly most vulnerable, and his decision
partner didn't fire, though.
Correct, and there may have been a crossfire situation. I can't speak for the partner. I'm not sure what his explanation is, but you know, there's certain factors that come into play when an officer decides to use deadly force or not use deadly force, and some of those factors are distance from the subject with the weapon, the ability of shielding or lack thereof, the ability to retreat, and I would just state that my client was in a position where he was closest to this individual. He had no shielding, and he was possessed with a lot of knowledge about the situation prior to him even getting out of his vehicle.
You know, the mayor and the superintendent of police have condemned your client's actions. The city has settled with the family for $5 million, and that's without a wrongful death suit. They decided that this was worth sort of closing the book on right away. I'm wondering what that says about, or if it says anything about the strength of your client's argument that his actions were justified, when clearly the city thought not.
Well, the city is not in the possession of the knowledge that that I have on this case. The city and the mayor and the state's attorney, they had not spoken to my client. They have not heard his views on this. And you know, with all due respect to the mayor and politicians and the state's attorney, they are not experts in the use of deadly force, and they are not police officers. So their opinion is essentially, it's not, we may not change their opinion, but my goal is not to change their opinion. It's to convince a judge or jury that the actions were justified under the law.
I guess, could you just bottom line it for us, Mr. Herbert? What was your client's thinking when he decided to use that level of force when none of the officers that was there on the scene, including his own partner, who was not far away from your client, why did he feel that level of force was necessary? Because
he was in fear of his life, and he was in fear of the lives of anyone else that was on the scene. You know, my client didn't have he didn't have a perspective of where every officer was at the time. When he got out of the vehicle, his vision was likely narrowed to essentially just the knife, the hand holding the knife. So yes, he believed that this individual was going to attack him and hurt him, or possibly kill him, or kill another police officer or a civilian that may or may not have been on the scene.
Just so we're clear, is it your client's contention, as it's been reported by some outlets, that McDonald lunged at him? Is that what your client has told you?
No, that came out, I'm not sure by whom it came out, but it's never been the position of my client that the individual lunged at him.
And so the threatening feeling came from what action on the part of the individual, on the part of Laquan McDonald?
Well, all the actions leading up to the deadly force. We can't just look at it from the split second prior to him shooting. We have to take it in the totality of circumstances. And at the point in which my client arrived on the scene, this incident had already been going for approximately, I think it was about 18 minutes. My client knew that this individual had stabbed a windshield of a police squad car where two police officers were sitting in there. He was aware of the fact that Mr. McDonald had stabbed and punctured a tire of a squad car where two police officers were sitting in it. He knew that there were no tasers available. So all those factors, he possessed that knowledge coming into the situation. And when he got out of his vehicle, it was a rapidly evolving situation, and he made a split-second decision based upon his perception and his training.
So the dash cam video shows moments in time, but I'm wondering how you feel about its release. Do you think it muddies the water, or does it clarify things? Does it help or harm your client?
Well, there's no question that at first glance, most people are going to come to the conclusion that his actions were unreasonable. We recognize that. We would have preferred that the video were not released. However, we don't have any legal basis to suppress it, and it's literally a decision that's out of our hands. But yes, all things being equal, I would have preferred that the video not be released, and it would have ensured, I think, more of the opportunity for more of a fair trial for my client. But the reality is the video is out, and we're prepared to proceed despite that fact.
Daniel Herbert, attorney for Chicago officer Jason Van Dyke, thank you for joining us.
Thank you.